After a Rhode Island car accident, your guide to claims and lawsuits. What happens after a car accident in Rhode Island? A car accident can leave you dealing with medical treatment, vehicle repairs, missed work, and phone calls from insurance companies, all while you are still trying to understand what actually happened. You're probably asking yourself, who is legally responsible? Which insurance company is supposed to pay? Should you give the adjuster a recorded statement? And what happens if the insurance company refuses to offer fair compensation? In this video, we're going to explain how Rhode Island car accident claims work, what you should do after a collision, how fault and insurance coverage are handled, what compensation may be available, and what to expect if your claim becomes a lawsuit. This is a general overview. Every crash is different, and even one detail can change which laws, deadlines, or insurance policies apply. The most reliable way to understand your rights is to discuss the specific facts with a Rhode Island car accident lawyer. If you or a loved one have been injured in an auto accident, contact Marasco and Nesselbush for a free, no-obligation legal consultation to get answers to your questions and start the path to recovery. Now let's start with the basics. What is a car accident claim? A car accident claim is an effort to recover compensation for injuries and other losses caused by a collision. In many cases, the claim is made against the driver who caused the crash and that driver's insurance company. But that is not always the full picture. Depending on the circumstances, a claim may also involve the injured person's own insurance company, the owner of the vehicle, a driver's employer, a trucking or transportation company, a vehicle manufacturer, or other responsible parties. The losses involved may include medical expenses, missed income, vehicle damage, physical pain, emotional harm, future treatment, reduced earning ability, and other economic and non-economic effects. A car accident claim normally begins outside of court. A lawsuit may become necessary later if responsibility is disputed, the available insurance is unclear, or the insurer refuses to offer fair compensation. How do you know whether you have a car accident case? Most car accident cases come down to a few basic questions. First, did another driver or party have a responsibility to act safely? Drivers have a duty to follow traffic laws and use reasonable care when operating a vehicle. Second, did someone fail to meet that responsibility? Examples include speeding, following too closely, driving while distracted, failing to yield, making an unsafe turn, ignoring a traffic signal, or driving while impaired. Third, did that conduct cause or contribute to the collision? A driver may have made a mistake, but there still needs to be a connection between that mistake and the crash. Finally, did the collision cause injuries or other measurable losses? Those losses might include medical treatment, time away from work, vehicle damage, pain, physical limitations, and other consequences. Do I need a police report or citation? A police citation may be useful evidence, but it does not necessarily decide the entire civil case. In the same way, the fact that no ticket was issued does not automatically mean that no one was legally responsible. Police reports and citations are good forms of evidence, but when the drivers give different accounts of what happened, other evidence such as photographs, video, vehicle damage, witness statements, and electronic data may become especially important. A lawyer can investigate that evidence and help determine whether the facts may support a claim. What should you do immediately after a crash? Your first priority should be safety. Stop your vehicle, check whether anyone needs emergency assistance, and move out of active traffic when it is safe and possible to do so. Call the police and request medical help if anyone may be injured. Rhode Island's Division of Motor Vehicles instructs drivers to report collisions to the nearest state or local police. It also states that a police report is required when someone is injured. Property damage exceeds $1,000. An unattended vehicle is struck or a domesticated animal is hit. Exchange information with the other driver, including names, contact details, driver's license information, vehicle registration, and insurance information. Try to remain calm, even when the other driver is upset or immediately begins blaming you. Do not argue about responsibility at the scene. Do not guess about your speed, the other vehicle's speed, or details you did not clearly observe. You should provide accurate information to the police, but you do not need to speculate or accept blame before the collision has been properly investigated. And remember, not everyone is physically able to gather information after a serious crash. You may be taken to the hospital or be too injured or shaken to document the scene. Failing to complete every step does not automatically prevent you from pursuing a claim. What information should you collect at the scene? When you are physically able to do so, take photographs and video of the accident scene. Document the positions of the vehicles, the damage to each vehicle, debris, skid marks, traffic lights, road signs, and the surrounding area. You may also want to record the road conditions, weather, visibility, and any construction or hazards nearby. Look for businesses, homes, or public areas that may have security cameras facing the road. That footage could be overwritten quickly, so identifying possible cameras early can be important. Get the names and contact information of anyone who witnessed the crash or saw what happened immediately afterward. Record the name of the responding police officer and the agency handling the report. If you have a dash cam, preserve the recording before it is automatically deleted or overwritten. The Rhode Island DMV recommends documenting the exact location and time of the collision, the other driver's license, registration and insurance information, witness details, the responding officer's name and descriptions of the damage and injuries. Even if you cannot gather all of this yourself, an attorney may be able to obtain police records, contact witnesses, and request available video footage. Should you get medical care if the injury seems minor? Some car accident injuries are immediately obvious. Others may not become noticeable until later, once the shock and adrenaline from the crash begin to wear off. Do not ignore pain, confusion, dizziness, numbness, weakness, or other symptoms simply because you were able to walk away from the scene. Accept emergency care when you need it and seek a medical evaluation if you believe you may have been injured. Be honest and complete when describing your symptoms. Attend follow-up visits and complete the testing, therapy, or rehabilitation recommended by your medical providers. Medical treatment is important for your health, but it also creates a record of the injuries, when the symptoms began, and how your condition progressed. A long delay in treatment can make the insurance claim more difficult. The insurer may argue that the injury was not serious, that it was caused by something other than the collision, or that the person failed to take reasonable steps to recover. That does not mean every person must go to an emergency room after every minor collision. The appropriate response depends on the person's symptoms and circumstances. The main point is to take possible injuries seriously and make decisions based on your health, not on whether you are worried about inconveniencing anyone or creating an insurance claim. What evidence can help prove a car accident claim? Evidence in a car accident case generally needs to help establish three things. 1. How the collision occurred. 2. Who was responsible. 3. How the crash affected the injured person. Evidence about the collision may include photographs, videos, police reports, witness statements, traffic camera footage, security recordings, and dashcam video. In more complicated cases, it may also include cell phone records, vehicle event data, roadway evidence, maintenance records, or an inspection of the damaged vehicles. Evidence about the injuries may include emergency room records, diagnostic imaging, treatment notes, surgical records, prescriptions, therapy records, and recommendations for future care. Financial evidence may include medical bills, wage statements, tax records, employer documentation, vehicle repair estimates, rental expenses, and receipts for other costs tied to the collision. The effect on a person's daily life may also be relevant. A serious injury can interfere with work, sleep, household responsibilities, parenting, exercise, hobbies, and basic independence. In some cases, attorneys may consult doctors, accident reconstruction professionals, engineers, economists, vocational experts, life care planners, or other qualified specialists. No single photograph, report, or medical record usually proves the entire case. Strong claims are often built from several pieces of evidence that support one another. Who may be responsible for a car accident? The other driver is often the first person considered, but they may not be the only responsible party. If the driver was performing job duties at the time of the collision, the employer may also have legal responsibility depending on the circumstances. If the crash involved a commercial truck, delivery vehicle, or other company vehicle, the case may involve the driver, employer, vehicle owner, maintenance company, cargo contractor, or other commercial parties. A defective tire, brake system, airbag, or other vehicle component could potentially lead to a claim involving a manufacturer, distributor, or repair provider. A dangerous construction zone or roadway condition may raise questions about contractors or government entities responsible for the area. In a chain reaction collision, more than one driver may share responsibility. Identifying every potentially liable party matters because different defendants may have different insurance policies and different evidence. One party may also try to blame another. A company may possess electronic records, inspection documents, employment information, or video that the individual driver does not have. This is why commercial crashes, multi-vehicle collisions, and accidents involving someone who is working should be investigated carefully before anyone assumes the case is only against one driver. How does fault-based insurance work in Rhode Island? Rhode Island generally uses a fault-based auto insurance system. That means the driver or other party whose negligence caused the crash may be responsible for the injuries and property damage that resulted. The Rhode Island Department of Business Regulation explains that bodily injury liability insurance protects against claims brought by people injured in an accident, for which the insured driver was at fault. However, the at-fault driver's insurance is not necessarily the only coverage that may become involved. Depending on the policies and circumstances, the injured person's own insurance may provide collision coverage, medical payments coverage, or uninsured and underinsured motorist benefits. A company policy may apply if the responsible driver was working. Other vehicle owners or businesses may also have coverage. The fact that one insurer begins handling the claim does not necessarily mean it is the only insurer that should be investigated. Which insurance policies may apply after a crash? The first possible source of coverage is usually the at-fault driver's liability policy. Bodily injury liability coverage may help compensate injured people for medical treatment, lost income, pain, disability, and other harm caused by the insured driver. Property damage liability coverage may pay for damage to another person's vehicle or other property. The injured person's own collision coverage may also pay for covered damage to their vehicle, usually subject to the terms of the policy and a deductible. Using collision coverage can sometimes provide a faster way to begin the repair or total loss process while the insurance companies investigate responsibility. Medical payments coverage, sometimes called med-pay, may help pay certain covered medical expenses regardless of who caused the crash. Rhode Island law generally requires applicable auto policies to provide at least $2,500 per person and $5,000 in total medical payments coverage. But the named insured may reject that coverage in writing. Uninsured or underinsured motorist coverage may become important when the responsible driver has no insurance, does not have enough insurance, or leaves the scene and cannot be identified. Every policy is different. Coverage may depend on the policy limits, vehicles listed, insured household members, written coverage selections, exclusions, and many other details. That is why it is important to review the actual policies rather than relying only on what one adjuster says may be available. How much auto insurance is required in Rhode Island? Currently, Rhode Island's financial responsibility requirements generally use minimum limits of $25,000 for bodily injury or death to one person, $50,000 for bodily injury or death to two or more people in one accident, and $25,000 for property damage. The law also recognizes $75,000 combined single limit. These are minimum insurance limits. They are not a statement of what an injury is worth. A $25,000 bodily injury limit may be exhausted quickly when someone requires surgery, extended hospitalization, or long-term treatment. The problem can become even more serious when several people are injured in the same crash and must share the available per-accident coverage. A person's medical expenses, lost income, and other damages may be much greater than the at-fault driver's insurance limits. That is one reason uninsured and underinsured motorist coverage can be so important. What if the other driver has no insurance or not enough insurance? An uninsured motorist claim may be available when the responsible driver does not have applicable liability insurance. It may also apply in certain hit-and-run situations when the driver cannot be identified. An underinsured motorist claim may arise when the responsible driver has insurance, but the available coverage is not enough to address the injured person's damages. Rhode Island law treats an underinsured motorist as an uninsured motorist for purposes of the state's uninsured motorist statute. The amount and availability of coverage still depend on the applicable policy, selected limits, coverage choices, and circumstances. Do not assume that there is no case simply because the other driver was uninsured, left the scene, or carried only minimum coverage. There may be uninsured or underinsured motorist coverage on the vehicle involved in the crash, another household policy, or another policy connected to the facts. In a hit-and-run case, report the collision promptly, look for witnesses or cameras, and notify the applicable insurance company according to the policy requirements. A lawyer can review the available policies and determine whether there may be additional sources of coverage. What is the difference between a property damage claim and an injury claim? A car accident can create both a property damage claim and a bodily injury claim. They are related, but they are not the same. The property damage claim may address vehicle repairs, the value of a totaled vehicle, towing, storage, rental transportation, loss of use, and damage to personal property inside the vehicle. The bodily injury claim may address medical treatment, lost wages, future care, pain, disability, reduced earning capacity, and other economic and non-economic losses. It is possible for the vehicle damage portion of the claim to be resolved, while the injury claim remains open. However, you should understand exactly what any document releases before signing it. A broadly written release may affect more than the issue you thought you were resolving. When there is any uncertainty, have the document reviewed before signing away legal rights. What happens if you are partly responsible for the crash? Being partly responsible does not necessarily prevent you from recovering compensation in Rhode Island. Rhode Island uses a pure comparative negligence rule. Under that rule, an injured person's compensation may be reduced according to that person's percentage of fault. For example, suppose the total damages are $100,000, but the injured person is found to be 20% responsible for the collision. The recovery would be reduced by 20%, leaving $80,000. Insurance adjusters may assign percentages of fault during their investigation or settlement negotiations. But an adjuster's opinion is not automatically the final legal answer. If the case reaches trial, the judge or jury acting as the fact finder evaluates the evidence and determines how responsibility should be divided. Comparative fault disputes are common in intersection collisions, lane change crashes, chain reaction accidents, and cases where the drivers give conflicting accounts. Photographs, video, vehicle damage, witness statements, and electronic data can become very important in these situations. What if the other driver blames you? It is very common for drivers to remember or describe the same crash differently. The other driver may claim that you changed lanes, stopped suddenly, entered the intersection too early, or failed to react properly. The insurance company may use that account to deny the claim or reduce the amount it offers. That does not necessarily end the case. Independent witnesses, nearby cameras, vehicle damage patterns, roadway markings, phone records, and vehicle event data may help show what happened. In serious or complicated crashes, an accident reconstruction professional may analyze the vehicles, scene, and available data. You should avoid getting into an argument with the other driver or trying to negotiate fault at the scene. Give the police accurate information, preserve the evidence you can, and allow the full investigation to take place. What mistakes can hurt a car accident claim? One of the most common mistakes is delaying medical care. Waiting too long may allow the insurance company to argue that the injury was minor or unrelated to the crash. Missed appointments, large gaps in treatment, and failure to follow medical recommendations may also be used to challenge the seriousness or progression of the injury. Another mistake is giving a recorded statement without understanding the purpose of the interview. Insurance adjusters may sound friendly and helpful, but their job is to investigate the claim for the insurance company. An uncertain estimate or casual comment may later be treated as a firm statement. You should never provide false or misleading information, but you also should not guess about your speed, distance, symptoms, or anything else you do not clearly know. Be cautious about signing broad medical authorizations. An authorization may permit access to records beyond the treatment directly connected to the collision. Do not accept a final settlement before you understand the medical outlook. Once a claim has been fully released, you generally cannot return for additional compensation because you later need surgery, cannot return to work, or develop permanent limitations. Avoid repairing, selling, or disposing of an important vehicle before necessary evidence has been preserved, particularly in a severe or disputed collision. Be careful on social media. Photographs, videos, location information, and comments may be reviewed by the insurance company or defense attorneys and taken out of context. Finally, do not assume that ongoing insurance negotiations protect the deadline for filing a lawsuit. A free consultation with a car accident lawyer can help you understand the process before you make an irreversible decision. Is a car accident claim the same as a lawsuit? No. A car accident insurance claim usually begins outside of court. The parties investigate the collision, review insurance coverage, gather medical and financial records, calculate damages, and negotiate a possible resolution. Many claims are resolved without a lawsuit. A lawsuit begins when a formal complaint is filed in the appropriate court. Filing a lawsuit may become necessary when the insurer disputes responsibility, denies coverage, minimizes the injuries, or refuses to offer reasonable compensation. A lawsuit may also be needed to obtain documents, testimony, or other evidence through the formal discovery process. And sometimes a lawsuit must be filed simply to protect the claim before the legal deadline expires. Filing a lawsuit does not automatically mean the case will go to trial. Many lawsuits are resolved through continued negotiations or mediation before a judge or jury is asked to decide the outcome. What happens during a Rhode Island car accident lawsuit? The lawsuit generally begins with the filing of a civil complaint. The complaint identifies the defendant or defendants and explains the legal basis for holding them responsible. The defendants must then be formally served with notice of the case. They will have an opportunity to respond, admit or deny the allegations, and raise legal defenses. The case then moves into a stage called discovery. During discovery, both sides exchange information and evidence. This may include photographs, reports, medical records, wage documents, written questions, and information about witnesses. The parties may also take depositions. A deposition is an interview conducted under oath. Drivers, witnesses, medical providers, company representatives, and experts may be questioned about the case. Serious or disputed claims may require expert review. Doctors may explain injuries and future medical needs. Accident reconstruction professionals may evaluate how the collision occurred. Economists, vocational experts, or life care planners may assess lost earning ability and long-term care needs. The parties may continue negotiating throughout this process. They may also participate in mediation, where a neutral third party helps them explore a possible resolution. If no agreement is reached, the case may proceed to trial. A judge or jury can then determine responsibility and damages based on the evidence presented. How long do you have to file a car accident lawsuit in Rhode Island? For many Rhode Island car accident injury cases, the general statute of limitations is 3 years from the date the legal claim accrues. For a typical collision, that usually means 3 years from the accident date. Rhode Island General Laws, Section 9-1-14, states that actions for injuries to a person generally must be brought within 3 years after the cause of action accrues. An insurance claim is not the same thing as a lawsuit. Calling the insurance company, submitting medical bills, or negotiating with an adjuster does not automatically stop or extend the filing deadline. You should also not assume that the insurer will warn you before time expires. Different rules or exceptions may apply depending on the age of the injured person, the identity of the defendant, whether the crash caused a death, whether a government entity was involved, and other case-specific facts. Some cases also have notice requirements that may expire much sooner than 3 years. Missing the applicable deadline may eliminate the right to recover compensation, regardless of how serious the injuries are. That is why the deadline should be reviewed early, rather than waiting until negotiations have already stalled. Do special rules apply to certain types of car accidents? Yes. Car accident cases do not all follow exactly the same rules. Deadlines, insurance coverage, notice requirements, evidence, and responsible parties can change based on the vehicles involved, who owned them, what the drivers were doing, and many other details. The situations we are about to discuss are only examples. They are not a complete list of every special rule that may apply. Commercial truck and company vehicle crashes may involve the driver, employer, owner, maintenance provider, cargo company, and other commercial parties. Electronic records, driver logs, inspection information, and company documents may need to be preserved quickly. Rideshare and delivery driver accidents may involve different insurance policies depending on whether an app was active, whether the driver had accepted a trip, and whether a passenger or delivery was in progress. Crashes involving government vehicles, public employees, or dangerous public roads may be subject to special notice procedures, filing rules, or limits that do not apply to an ordinary private vehicle claim. Multi-vehicle and chain reaction accidents may involve several drivers and insurance policies. More than one person or company may share responsibility. Crashes involving children or fatal injuries may also change who has authority to bring the claim and which damages may be available. Rhode Island also has a specific rule regarding seatbelts in civil cases. The failure to wear a seatbelt or child restraint cannot be treated as comparative negligence and is not admissible as evidence in the trial of a civil action. Again, these are only examples. Rental vehicles, out-of-state drivers, uninsured vehicles, defective auto parts, motorcycles, pedestrians, bicyclists, and other situations may involve additional laws or insurance provisions. One fact can change the applicable defendant, coverage, deadline, or legal strategy. Do not assume that a general rule found online automatically applies to your crash. A Rhode Island car accident lawyer can review the actual circumstances and explain which rules may affect your claim. What compensation may be available after a car accident? Compensation in a car accident case is intended to address the losses caused by the collision. These losses are often divided into economic and non-economic damages. Economic damages are financial losses that can usually be documented through bills, wage records, and receipts. They may include past and future medical expenses, lost wages, reduced earning capacity, rehabilitation costs, medical equipment, home assistance, transportation expenses, vehicle damage, and other measurable financial losses. Non-economic damages address the personal effects of an injury that do not come with a fixed bill. They may include physical pain, emotional distress, mental anguish, disability, scarring, loss of enjoyment of life, reduced independence, harm to a marital relationship, and other effects on the person's daily life. These examples are not a complete list. The damages available depend on the type of case, the evidence, and the specific ways the collision changed the person's health, work, finances, relationships, and future. A fair evaluation should account for reasonably anticipated future losses, not only the bills that have already arrived. How much is a Rhode Island car accident case worth? The honest answer is that car accident case values can vary by an enormous amount. Two crashes that sound almost identical can have dramatically different values once you examine the injuries, evidence, insurance coverage, and effect on each person's life. There is no reliable average settlement and no universal formula. A temporary injury that improves after limited treatment is evaluated very differently from a traumatic brain injury, spinal cord injury, or permanent disability that affects someone's ability to work and live independently. The type of collision can also make a major difference. A crash involving one driver with minimum insurance coverage is very different from a commercial vehicle accident involving several companies and multiple insurance policies. The value may depend on the nature and severity of the injuries, whether they are permanent, the cost of past and future treatment, lost income, reduced earning ability, and the impact on daily activities. It may also depend on whether fault is clear, whether the injured person shares some responsibility, how strong the evidence is, how many people were injured, and which insurance policies or other sources of compensation are available. Policy limits can affect the practical amount of money available, but they do not necessarily determine the full value of the person's damages. In a severe injury case, attorneys may work with medical specialists, economists, vocational experts, and life care planners to understand future medical costs, lifetime care needs, and the effect on earning capacity. This is why online settlement calculators and broad averages are often misleading. They cannot account for the type of crash, the specific injuries, comparative fault, available insurance, or the quality of the evidence. The only meaningful way to estimate a claim is to review the actual facts, medical records, losses, insurance policies, and legal issues. Even then, no responsible attorney can guarantee a specific result at the beginning of the case. How long does a car accident case take? There is no standard timeline. Some claims can be resolved relatively quickly. Others may take much longer because of the severity of the injuries, disputed fault, multiple defendants, or complicated insurance issues. The length of medical treatment is often important. A person may not know immediately whether an injury will heal, require surgery, or cause permanent limitations. Settling too early can create serious problems if the injured person later learns that they need additional care or cannot return to the same work. Cases involving expert testimony, commercial defendants, or several vehicles may also require more investigation. If a lawsuit is filed, the parties must complete discovery, depositions, expert review, motions, and other court procedures. A case may settle before a lawsuit is filed, during discovery, at mediation, shortly before trial, or at another point in the process. The goal should not be to make the case take longer than necessary, but it is also important not to rush into a resolution before the full medical, financial, and personal effects of the collision are understood. What does a Rhode Island car accident lawyer actually do? A car accident lawyer can investigate how the crash occurred and identify every person or business that may be responsible. The legal team may obtain police reports, photographs, surveillance footage, dash cam recordings, electronic vehicle data, and witness statements. They can preserve damaged vehicles and other physical evidence when necessary. They can review every potentially applicable insurance policy rather than relying on the first coverage identified by an adjuster. The attorney can handle communications with insurance companies, respond to allegations of fault, and collect the medical and financial records needed to document the claim. In serious cases, the lawyer may work with medical providers, reconstruction experts, economists, vocational specialists, and other professionals. The lawyer can calculate current and anticipated losses, prepare a settlement demand, and negotiate with the insurers. If the claim cannot be resolved fairly, the attorney can file the lawsuit before the deadline, handle discovery, take depositions, present legal arguments, and prepare the case for trial. Just as importantly, a lawyer can explain the available options at each stage so the injured person can make informed decisions while focusing on medical care and recovery. Why choose Marasco and Nesselbush after a Rhode Island car accident? At Marasco and Nesselbush, we represent people and families affected by serious motor vehicle accidents throughout Rhode Island and southern New England. Our 18-attorney team has more than 350 years of combined legal experience handling personal injury claims, including complicated car, truck, motorcycle, pedestrian, and other roadway accident cases. We have recovered more than $500 million for our clients. Our Rhode Island offices are located in East Providence, Wakefield, Warwick, Woonsocket, and Middletown, making it convenient for injured people throughout the state to reach our team. We also provide English and Spanish language support throughout the legal process. When we take on a car accident case, we investigate what happened, identify the available insurance coverage, deal with the insurance companies, and document the full effect of the injuries. Eligible cases are handled on a contingency fee basis. That means there are no upfront attorney fees, and you do not owe attorney fees unless we recover compensation for you. What should you do next? If you were injured in a Rhode Island car accident, prioritize your medical care and report the collision. Preserve whatever evidence you can, including photographs, video, witness information, and insurance documents. Be cautious when speaking with insurance companies and do not rush to sign a release or accept a settlement before you understand your injuries and legal rights. Do not assume that an open insurance claim protects the deadline for filing a lawsuit. Most importantly, remember that every collision is different. The responsible parties, insurance coverage, damages, and legal rules depend on the specific facts. Contact Marasco and Nesselbush for a free no-obligation consultation. We can listen to what happened, review the available information, identify potential insurance coverage, and explain the legal options that may apply to your situation. And remember, you pay no attorney fees unless we recover compensation for you.